This is AKASHVANI, Bengaluru. Good evening and welcome to tonight's Yuvavani.
Good evening, everyone. I am Sama Asya. I am a public speaking instructor and a curriculum designer, and I have a company called Soapbox where I teach children. Today, I will be in conversation with Zaid Nasser, who is a legal intern.
Hi Sama, good evening. My name is Zaid Nasser and I am a student at St. Joseph College of Law and as well as a legal intern who's been working in this field since the past 2 to 3 years now under various other advocates and also under a few advocates in the High Court of Karnataka.
So, today we will be talking about the 3 new criminal codes which have replaced the IPC, CRPC, and IEA. So, our constitution as well as laws carry a certain colonial baggage. We can see its influence of colonialism in our politics, in our policies, and even laws. So, how do you think, Zaid, the IPC, CRPC, and IEA carry that colonial baggage?
The IPC, CRPC as well as the Indian Evidence Act, they all carry remnants of colonial baggage because the very origin of these kind of laws was from the British rule. And these laws were crafted during the British period, the British colonial period, with the primary goal of maintaining control over the Indian population. And they were meant to consolidate British authority. The previous codes, the IPC, the CRPC, the Criminal Procedure Code and the Indian Evidence Act, they established and they enforced a lot of colonial control over the people. The IPC, for example, was enacted in 1860 and it was designed by the British to impose a uniform legal framework across India on all of its population. But as we know, India is a very diverse country. It has a lot of social norms that vary across the states of the country. We cannot enforce a single uniform control code over the entire country. Even if we take examples like Section 124A, that is sedition, that was in the IPC, that was targeting Indian political leaders and activists who were opposing the British rule. And this illustrates how IPC was used as a tool of colonial expression.
Now that we have understood what the IPC, CRPC, and IEA were, how do you think replacing them could be any different or better for us as Indian citizens?
Understanding the colonial baggage that we discussed about in the previous question, it helps us in critically analyzing how these laws have evolved and what are the kind of differences in the reforms that were necessary to align these with the modern democratic values and human rights situations of India. The Indian legal system currently has introduced the Bharatiya Nyaya Sanhita Bill, which replaces the IPC. And the main objective of all these bills similarly is to modernize and address the current societal issues and also reflect on contemporary values. There are many revised offenses in order to match to modern social norms, and also it has more focus on rehabilitation and it is having a more of a victim-centric approach. Whereas the Bharatiya Nagrik Suraksha Sanhita Bill that replaces CRPC, that has a main objective to improve efficiency and it reduces delays in the legal process that we are very aware of, which is a major problem in the judiciary of India. And it has more simplified procedures. For example, it introduces clearer and more transparent procedures for investigation or for arrest or for trial in order to expedite justice. It also incorporates a lot of digital tools, for example, electronic filing, digital evidence. These all improve in enhancing the efficiency of the protection of the citizens of India. The Bharatiya Sakshya Bill, that is the replacement for the Indian Evidence Act, this has more simplified evidence rule. For example, it focuses on fairness and it makes evidence more accessible and less rigid than the previous Indian Evidence Act that we had. It also enhances admissibility, that expands types and sources of admissible evidences, and it improves the ability to establish truth in the court. These updates, they mark a significant shift towards more contemporary, equitable and efficient legal system.
So, now that these 3 criminal codes have been catered to the Indian audience, let's say, what do you think these codes have failed to cover, or what could they have worked upon?
See, while the new laws, the Bharatiya Nyaya Sanhita Bill, the Suraksha Sanhita Bill and the Sakshya Bill, they represent significant progress over the previous codes that we had. there are still some areas where these fall short. For example, one of the very important provisions that it fails to make is with regard to police accountability. See, despite procedural updates, despite the new laws, these new laws do not fully address the need for comprehensive police reforms, effective measures to ensure police accountability, and also to prevent abuse of power and systemic corruption. Other issues that these new laws fail to address are issues like judicial backlogs, gender based violence, cybercrime, and data privacy, which is a very important notion to address in this era, and also environmental crimes, which a majority of the people have raised concerns over, and some of the more smaller problems that are related to mental health considerations and the implementation challenges of these new bills for the larger public.
So now that all these three criminal codes have been changed, when we live in a generation of doom scrolling or just information dump in general, don't you think the younger people have strayed away from politics because of this reason? And is this also contributing to the fact that whenever such criminal codes or any policy changes in the country, we as the youth are usually unaware about it?
Yeah, so see, we do obviously live in a world of doom scrolling. It is very evident from the generation that we have right now. And the other issue that is the root cause behind doom scrolling is mostly information overload. And this is what is the prevalent cause that needs to be addressed. The constant bombardment of negative news and vast amount of information, this can significantly alter the younger generation's engagement with politics and legal matters. See, doom scrolling on a very general perspective, it causes mental fatigue, and it causes apathy in young generation because of being constantly exposed to distressing news without seeing any tangible solutions. These people, they in the end become delusioned with the political processes and legal systems and do not have interest in getting into any of these matters. What we need to do is garner more impact on legal awareness, and we can reduce the focus on sensational news and viral contents, and we have to engage the youth with more relevant topics such as legal rights, civic administration, and this will contribute to generating more awareness of these kind of laws with the younger generation. Also, one another solution to this is with introducing civic norms and legal policies in the general curriculum for students from 10th, 12th, and henceforth as subject. And the consequences that we are facing right now is limited engagement with the younger generation. They have no idea or a very limited idea or idea from political sides that only show you a certain aspect what they want you to see of these political reforms, and this is one of the main reasons why the younger generation is not very politically or legally inclined to learn and study about these new laws.
So, if the current generation of young people are unaware, it could rather make them ignorant of the law. So, let's say they have been ignorant of the law for so long. So, what they do, let's say an action, would it be considered illegal because they were ignorant of the law?
So, see, this is a very good question because I've had many people even ask me about this, where ignorance of law, if it is considered as a valid defense. The principle that is rooted in this legal maxim is called ignorantia juris non excusat. That translates to ignorance of the law is not an excuse or is no excuse. So this is the general rule that the legal system assumes that all the individuals are aware of the law and that they are expected to know and comply with the legal standards. Therefore, not knowing that an action is illegal typically does not absolve one of the responsibility with the action. But there are a few exceptions to this. If you look at more complex or obscure laws, such as in rare cases if the law is exceedingly complex or obscure, then a person can demonstrate that it was not reasonably possible for me to know about or be aware of this law.
Because the law was that complex?
Yeah, exactly. Because the law is complex or difficult to understand or difficult to decipher, this can be sometimes be a valid defense. The court might consider this in mitigating circumstances. However, this is not common. The other is mistake of fact. So we need to understand the difference between mistake of law and mistake of fact. A mistake of fact is basically a defense that is based on a genuine misunderstanding of fact rather than the law itself. And this might be considered. For example, if someone mistakenly believes that their action is lawful, but based on incorrect information, this could be a valid defense in some cases. Judiciary might consider this based on their understanding of the case.
So now, as an aspiring lawyer, you surely must have studied the 3 previous criminal codes. And now, do you think with the changes in them and with the replacement of these three new criminal codes, your syllabus has changed and has your participation in court proceedings changed?
See, the syllabus I am studying right now has not changed currently. One of the major reasons behind this is because the delay in updating the curriculum, specifically in our country. The laws were released to the public around, I think, 8 to 10 months back. But even now, we have not seen significant change in the curriculum that we are following. There have been efforts in college to change or to educate the students of the final year or the fourth year of law with seminars or with more public interaction courses regarding these new laws. It impacts a lot on court participation because in the courts, when these laws are already in action, we as lawyers who are about to go into this field and go and start arguing or go and start taking cases, we need to be very well versed with the new updates that these laws have brought about. Even though majority of the laws is very similar to what we previously had, there are significant changes in a few important laws that are very, very much used or very much with the need of the hour to have changes. And this, for a lawyer, I think this all goes on for continuous learning. So across our legal career, we have to keep learning and keep updating ourselves with the new laws that come about.
As a young citizen of this country, what do you think are the different ways through which I could educate myself about these laws? And how do you think the government could also make it easier for us to understand the laws and be aware of the law?
Exactly. See, as citizens of India, we need to know what these laws hold importance for us. If you want to try learning these laws on your own, I think legal aid clinics, they're a very important part of the entire ecosphere of law in India. They will be able to educate you a lot with practical exposure on these kind of laws. But it's very scarce that you find these kind of clinics in your area. There are other modes, are educational videos or podcasts online or interactive platforms like LawSeco or other websites that can help you with understanding the actual essence of these new laws rather than just listening hearsay information from news channels or from broadcasters. And the last and final is obviously online resources. Whatever we find, if it is a genuine resource or a genuine website, we might be able to learn.
Thank you so much, Zed. That was quite informative for me, at least as a young citizen, to understand how to analyze these laws and at least apply them in my life. This is Sama Asia, and I was in conversation with Mr. Zaid Nasir, who is a legal intern and an aspiring lawyer. And today we discussed the 3 new criminal codes and how a youth must be aware of these. Thank you.
This program was brought to you by AKASHVANI, Bengaluru.